Hi, and welcome to another edition of the Trustcast Show. And we're really happy to have with us this morning Mike Guasco.
Good morning.
Good morning. So, Mike, did I pronounce the last name right or did I butcher it?
You did, actually. I've heard many variations of my name over the years, but you got it right.
Okay, fantastic. So, today's guest, Mike, spent years on the other side defending some of the biggest employers in the country at the world's largest employment law firm before flipping sides to fight for the workers those companies were trying to defeat. Mike, you've seen both rooms. What made you walk out of one and into the other?
I just got tired of it. I had a trial near the end of the time on the defense side that I genuinely did not believe in the defense. Um, and I didn't think we should go to trial, but the client wanted to. And I had a real hard time in that trial, and I decided that it was time to switch to the other side, and the opportunity arose, and to be able to open my own firm, which then allows me to choose my own cases. Nobody
Hmm.
chooses them for me.
So I'm going to ask you some questions that maybe pose from the employee side. So if something just bad happened at work, I was passed over, demoted, written up after I complained. What do I do in the first 48 hours?
First thing is try and write down as much as you can. Document, document. Then if you know a lawyer, give them a call. If you don't, your local bar association will very likely have a referral list of attorneys that specialize in particular areas of the law. So, for example, I'm on the local referral service for housing discrimination and employment cases. If somebody calls with a personal injury question, they don't get sent to me. They get sent to people that specialize in that.
So why shouldn't I just go ahead? My cousin's a lawyer. Why shouldn't I just go ahead and call him?
You can't. If you give your cousin a call and say, "Do you know somebody that specializes in this?" There are lots of areas of the law, and they're very, very different in practice. For example, family law has an entirely different set of rules that I just don't know. So I don't even know where the potential landmines are to know to be able to avoid. So you definitely want an attorney that specializes in the area that you're focused on. But with that said, a lot of times the attorney that you know can be a good first stop for referrals to people because they know the community, they know the reputation of individuals.
Okay, that makes sense. So when do I know that a bad situation at work has crossed into the area of, an illegal sort of situation?
Hard to say, and it's what I would say is you never really know. So if you have a question, call an attorney and ask. Um, because there's also the question of even if it's crossed into illegal, is litigation the right solution for you as an individual? So it's not just when has it crossed from being annoying, upsetting, frustrating into illegal. It's also knowing what's the right next step for me as an individual.
So how often do you advise clients who come in, they say, okay, I've got this situation. It's turned into a hostile workplace. My boss is just an ass and he's just being mean because he can be. And there's nothing I can do. He's making it just miserable to show up um, for work. What do you tell somebody in a situation like that?
The first thing is to try and find out, is this unique to that individual, or is this a boss that's just one of those guys. Um, because lawyers use the phrase hostile work environment really is a shorthand. It has to be hostile because of a protected class. So race, gender, sexual orientation, gender identity, religion, age, that type of thing, or retaliation for a specifically protected event. I always say, unfortunately, it's not illegal to be a horrible boss and a horrible human being. It only becomes illegal when you're a horrible boss because of somebody's race. So a lot of times potential clients call me and want to talk about everything that's been happening. And they get really frustrated when I start going, no, 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 let's go back to before things started happening and talk about that and talk about a lot of different things to find out and to really dig into, is this person just a horrible boss or are they acting illegally?
So let's say, mm, what are some of the class? So let's say I have a different political viewpoint than my boss, and I don't really wear that on my sleeve, but it just somehow comes out, and he finds out he's one way, I'm the other way, and then suddenly I'm treated. Is that a protected class, or can that be a protected class, or no?
It can be, and it really depends on the state. Um, in California, political views are a protected class, but they're protected to a lesser degree than some of the other protected classes. And the reason for that is the state has decided to kind of balance, if somebody has a business, they don't necessarily want a white supremacist working for them and representing their business to the public. Well, where do you draw the line between political views that should be protected and political views that are so outside the bounds that they shouldn't be? And courts really aren't good at drawing those kinds of lines. So, with political views in particular, there is a balancing test that's not necessarily seen in other protected classes.
Okay, that makes sense. So my boss says it was a performance issue. How do I discern, is that a real story or is just his cover for doing what he's doing?
Partly depends on how long you've been with the employer. If you've been with them for a long time, can you show a pattern of consistently either average or ideally good, strong performance reviews? And then you get a new supervisor and suddenly those numbers plummet. Um, or you complained about something that happened at work and then the numbers plummet. So it really is kind of watching for trends and also watching for trends in assignments, who's getting what, are employees of a different race getting preferential treatment? Do they seem to always get the better assignments? um, or given more slack on things. Comparators is a big thing that we look to. Excuse me. And see, was there somebody that should be in the same situation discipline wise, but isn't? And then ask why the difference.
I'm going to take a contrarian approach here. That's I just occurred to me. So what if someone new moves into a position of power at this corporation, and you are a white man, and then they take and you've been doing really really great, and then and this is just a hypothetical, and then all of a sudden you have a different approach that's been employed in the at the employees, and they've decided they're going to employ some sort of DI or something like that. and then they suddenly just take you out of your position, demote you, and put someone of a different race or ethnic background or something like that above you. Is that considered discrimination? Not necessarily nationally, but in California.
Depends on the circumstances. And so, you specifically mentioned the maybe change in strategy, change in approach. If somebody has more experience with a particular approach. So, for example, I had a situation many years ago when I was still representing companies that the company decided to switch to a more sales aggressive approach. And instead of the focusing on existing customers as much, they were really putting a lot of eggs into the getting new customer approaches. Well, some of their higher ups were just outstanding enterprise relationship managers, but they weren't necessarily salespeople. And so there was a legitimate business reason for replacing those folks.
Mhm.
Um, if it is, but diversity of viewpoint is a legitimate business reason. So it can be hey, our backgrounds are just different. And if we want to expand our customer base, knowing what is going to attract potential new customers who we don't know about, and how do we get into those spaces? So there is a legitimate reason to be bringing in a variety of backgrounds, of understandings, of cultures.
So I guess to put a point on this, it's just an interesting conversation because I think that I think it would be interesting to the audience to know this. If I were this hypothetical person, a white male who had applied, who was with this organization for many, many years, and then someone came in that was of a different ethnic background and was promoted above me, and I was demoted, even though I had been performing really well. Is that something that a case that would be worth taking on? I mean, I know there's a lot of other parameters in there. Is that something that you could argue successfully if you were to make the case, well, this other person was not as qualified, and that it was done specifically um, for for racial reasons or something like that. Is that an argument that can be made in the state of California? I'm not making a political statement one way or the other. I'm actually as a point of law. That's the question.
Yeah, and that's fair, and I'll answer both. Kind of on the political side and the legal side. Is it a case that could be pursued? Absolutely. But depending on the situations, is that a case I would choose to take? No, I wouldn't. I tend to focus on cases where there has been just historically entrenched discriminatory practices. And even in cases where an employer is as well meaning as possible, because of just how deeply entrenched into the system, there are some levels of discrimination. I choose to focus my limited time on those types of cases. Does that mean that, your hypothetical is any less legally valid? No. It's just there's only 24 hours in my day, and I
Yes,
have to pick and
yes.
choose where to put my focus and my energies.
Okay, thanks. That was a good answer and well thought out. So I'm still employed, but things are getting worse. Do I have to wait until I'm actually fired before I can take action?
That is an excellent question. And I'm going to give two answers to that. Answer number one is no, you absolutely do not. There are what are called adverse employment actions that are lesser than termination. Now, the second half of that answer, and the reason that I laughed a little bit is, I mentioned earlier about there are only so many hours in the day and people need to choose where they focus. There are a lot of employment lawyers in California that have decided that for a variety of reasons, they won't take any case until there has been a termination.
Mhm.
I don't do that. I do take cases with ongoing employment, but they do raise a whole host of complicated issues. And when I take on a client like that, one of the first things I ask is, if you had your perfect ideal outcome, are you still employed with this company at the end? Because that really impacts a lot how the case is approached. And so because of that, there are a lot of complicated factors that go into bringing a case before you've been fired.
So the whole idea, whether you've been fired or not been fired, of going to an employment lawyer brings up a whole set of fears. And the major fear is that I'm sure that you hear this. The major fear is, oh, shit, if I go to an employment lawyer and report this, my reputation is ruined. I'm never going to get another job. Can you speak to that issue?
Yeah, I can. I mean, is that a risk? Absolutely. It depends on the community that you're in. What do you do for a living? Some jobs are a lot more into everybody else's business than other professions. So that is always something I talk about with potential clients, and I talk about it up front and really dig into their personal situation because that absolutely can be a concern and is a legitimate one. But
Okay,
what I'll
so
say
what?
is talking to the lawyer to begin with, even as a potential client, when I'm talking to somebody as a potential client, that gives rise to the attorney-client privilege. So I'm never going to tell anybody what a potential client tells me, even if they don't sign me or if I don't sign with them. Even if I decline a case, their privilege is still intact. So it doesn't hurt to call and have that conversation.
Okay, that makes sense. So what should I never say to HR after something happens to me? I feel like, I don't think this is right. And what should I if I go to HR, should I go to HR? And what should I never say if I go there?
So this is another one of those where it's kind of a complicated two-step answer. And it's going to seem contradictory. Should you go to HR? Yes, you should. What do you keep in mind when dealing with HR? HR is not your friend. HR is there to protect the company, not to protect you. And so, I say this, and even though that seems extremely contradictory, yes, you should go to them, but keep in mind that they're not your friend. Goes back to something that I said at the very beginning of the conversation. When you don't feel like something is right, what should you do? Document, document, document. And that includes going to HR and doing it by email, having records. Even if you don't get to keep those records, if you get fired during the discovery process, we can get a hold of them.
So if this is your son, so this goes to a more, and your son is somehow been treated unfairly at work, and he says, and let's assume that you're not an employment lawyer. I'm going to set up this hypothetical situation. Let's assume that you're not an employment lawyer, and he has been treated unfairly at work. Would you tell him to go to HR and report that, or would you tell him to go to a lawyer and discuss over the situation to determine whether I should go to HR or not?
I would say go to HR no matter what. I
Okay.
would say if you want to then reach out to an employment lawyer at the same time, go ahead and do that. But do go to HR, because one of the big things, I mentioned earlier, we look for comparators. Well, on the employer side, we look at trends. Did this person say everything is great, 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 great? They start showing up late to work on a daily basis and start getting written up for that, and then are eventually put on a performance improvement plan, and then is the first report to HR. What's the credibility level of that? So that's why I say go to HR early as well, because what you don't want to have happen is it to look like you went to HR to protect yourself.
That makes sense. Okay, that's good advice. So, what should I document and what's the right way to do it?
Um, i- what should you document? Whatever just feels off. And if it's gotten to the point where there's a particular individual that you're having difficulties with, what was your interaction with that person for the day? What's the right way to do it? There really is no right or wrong way to do it. Um, some of my clients are using Google Docs more and more because it has a built-in history trail, and you can show exactly when a particular piece of text was entered into that document. And that helps to show that it really was contemporaneous. It wasn't something that you went after the fact and kind of invented. But, even if it's just in a journal that you're handwriting, that's fine too. Whatever you feel comfortable doing, but just make sure you're doing it.
Okay, so walk me through what actually happens from the moment someone calls you, you decide to take the case until the case resolves.
So cases can go a wide variety of ways. The way I generally approach my cases starts with a couple of premises. One is every employee in the state of California is allowed to request their personnel file, and it has to be produced within 30 days. They can request their payroll records, which have to be produced in 21 days. If the employer messes up and doesn't send the records, there's a small penalty attached to that. Um, but importantly, you're able to seek attorney's fees in recovering that penalty. So it gives a lot of leverage on cases. So what I do is I send a letter that just says, here are all of the things that I understand are what are happening, and here's why that is illegal. And then I say, and pursuant to these statutes, I want my client's personnel file, I want my client's payroll records. And once I get those, I go through them with a fine tooth comb. Is there evidence in there to support what I suspect is going on? Are there other things that I didn't think of? And from there, it can go a few different ways. Option number one really kind of depends on the employer and how much they want to be done with this early and quietly. Some employers reach out and say, hey, can we try and resolve this before even going the route of litigation? And yeah, we can talk. And sometimes that can even be a pretty formal process. And it can be a fairly long process if the parties want it to be. If it's a matter of, hey, we really think that both sides have some good arguments, and we need somebody that really we all trust to help us bridge the gap, and you want to go with a mediator. I've had plenty of clients do that and do that successfully. Option number two is the fighting route. And even within that, it can go two ways. One is if you have signed an arbitration agreement that is binding, and there are a whole lot of reasons that it could be or could not be binding. Or if you want to keep it quiet and you want to go to arbitration, it can go through the arbitration process, or it goes through traditional in the courts litigation. And so it really kind of can go a variety of ways. And the first step is one of the few steps where the employer really holds most of the cards. Um, they can choose to engage in good faith, or they can choose to make you fight.
So, what does it cost to hire you, and how does most people's payment work?
So for me, like most plaintiffs' attorneys, I do everything on contingency. And what contingency is, I'm sure you've seen the ads on TV. It's usually some lawyer dressed in a suit that's pointing at the camera. If I don't get you money, you don't pay. That all that is a contingency, which means I get a certain percentage of what is recovered based on when in the process we get that recovery. How a particular contingency plays out works differently with different attorneys because there are different percentages that can be used. There are different times where there can be potential escalators. How are costs calculated? So there's a lot of things that go into what is a contingency. But for me in particular, client doesn't pay me a penny until a check is in our firm mailbox. And at that point, it's me depositing that in what's called a trust fund, which is a special kind of account that is money that is not definitely mine and is being held for the client, and the bar regulates those very, very heavily. Um, and then we agree on, okay, of this check amount, how much goes to me and my firm and how much goes to you. We agree that it's calculated according to our agreement, and then I send a check your way. So my clients don't pay me anything. The slight exception to that is I do some restraining order work, and those are on an hourly basis, and they usually I will require some level of a retainer that gets drawn down as I work, and if I finish without exhausting it, you get the remainder back. Or if more work needs to be done, then we just refill the retainer. So that's kind of the one exception to my clients don't pay me anything until it checks in the mailbox.
So, do you have some of those commercials? I'll get you money or you don't pay.
I don't. I've been very, very fortunate, in that I apparently have a pretty good reputation, and I have gotten the vast majority of cases that have come in my door have been referrals from other attorneys. So no, I have not. I knock on wood, I've been very lucky. I have spent nothing on marketing other than the whatever the monthly rate I pay for the firm website.
So, how long do these cases usually take?
If it goes the first route, the less contentious, 6 to 9 months is pretty average. If it goes the arbitration route, it's usually about 18 to 24 months. If it goes the court route, it can be 3 to 5 years.
Hmm. So people are motivated to stay out of court, I would think.
Yes, very
So
much so.
What's the difference between filing with the EEOC or the CRD versus just suing?
So, no matter what you do, you need to get what's called a right to sue letter from one of those organizations. There's a couple ways you can do that. The way I generally do it with my clients is I go in and get what's called an immediate right to sue, which says the day that I put that in, they send the right to sue letter. Um, there are a couple of differences that are practical differences. Filing directly with the EEOC or the CRD and asking them to investigate, they will investigate and potentially take the case themselves. And if they do that, you generally do not pay a contingency. Unfortunately, because those entities are so horribly underfunded,
Hmm.
um, they only take the most outwardly egregious. They have found a smoking gun. There's a video of the supervisor using a homophobic slur, for example, um, uh, e- or mocking somebody's religion openly, short of something along those lines, the agencies aren't going to take it. So a lot of times clients think, oh, well, I'm going to have them investigate and that'll help give us leverage in our lawsuit. No, it actually isn't, because they're not going to take the case and they're going to close it as no findings. And the defense attorney is then going to wave that around and say, look, even the government says no problem. Um, with people not understanding that that doesn't actually mean anything.
Oh, I could see how that could. So your best course, you said you need to file with those one of those two organizations, but then
Yes.
how do you get them? So wait a minute, I don't want you to investigate. I just want to file here. How does that work?
So it literally is exactly that. When I log into the CRD website, there are two buttons. There's one that says I want to submit a case for review, and that's it's going to go to an investigator who's going to do a preliminary call, um, and then is going to do a preliminary judgment as to whether or not they take the case. There's another button that says issue immediate right to sue letter. And I just go in and I put in the relevant information and click submit. And about 3 minutes later, I get an email with the right to sue letter attached.
So I can see how this could be a common mistake that people, because you talked about them holding up the letter. Wait a minute, even the government says this is not is this a, it seems like it would be a common mistake that one of your plaintiffs would make. Is that true? And how, assuming that it is true, this two-part question, you gave me some two-part answers. Assuming that it
That's
is
fair.
true, um, um, does it really make it harder to defend the claim?
So, two-part answer is the first one is yes, it is a mistake. And the second answer is it depends on when in the process that mistake is discovered. If it's still in the initial phases, for example, if I get a call from a prospective client who says, "Oh, and I filed with the CRD last week." That's easily rectified. I ask for the case number, I log in, I say, I now represent the person. They get an email to confirm it before the CRD does anything. Um, and then I say, switch this to a right to sue, and I get the immediate right to sue. And no harm, no foul. If it's more into an active investigation, then there will be a letter of no finding. And for the most part, courts exclude the letters of no findings. So as long as it's at that point, it's not really a problem. It's not unless the client has let the entire process play out. The CRD has issued an unsubstantiated letter, and then they call the plaintiff's attorney. That's when it is difficult, if not nearly impossible, to undo any potential damage from that.
Hmm. Well, that's kind of a, well, I wouldn't say a catch-22, but it seems like something. So really, someone that seems like something that would be very frustrating if you're in a situation where you feel like you're egregiously violated, and then you made a mistake in the way that you filed things. Uh,
And that's why, I say this, and a lot of folks really think that when lawyers say this, that it is somewhat self-serving. And to an extent, it is. But it also is very valid. That's why you contact an attorney early. Talk about it. Make sure that you're not accidentally stepping on the rake yourself without even knowing it.
So, what can people actually win? What does damages look like in real dollars? I know that there's not like, okay, but you're going to win this much money, but um, just an idea based upon, maybe some cases that you've had.
It it's such a cliche, but it is really true. Every case is different. I've had cases where we settled for 7 figures, and the client was, ecstatic. And I've had cases that we've settled for low 6 figures, and the client is ecstatic. Every case is so different, and there are so many different variables that go into it. What's the venue? Is it arbitration or is it a jury trial? Is it federal court where you need a jury to be unanimous, or is it in state court where you only need 9 out of 12? Is it in Los Angeles County, or is it in Stanislaus County? Uh, is it a situation where you've got very, very hard, strong documentary evidence to back it up? Is that supposed to matter for damages? No, it's not. But it does. A lot of times juries, as much as everybody claims to hate jury duty, without fail, every juror I've talked to after a case ends up saying that they really enjoyed the process. And more importantly, I can tell they tried really hard to get it right. And so when you've got a case that isn't necessarily as strong, and the jury's pretty sure that they agree with you about what happened, but they're just enough doubt that they don't wanna necessarily, hurt the employer, so the number can be lower. It's not supposed to be, but it happens all the time. So there's so many different factors that go into it that, it really is impossible to say. And then there are other times where I've taken cases and it really was one of those, my gut tells me that something is wrong and that I'll be able to find evidence of it in discovery. And then either I don't find the evidence, or even worse, there's evidence that shows my gut was wrong. Then those, all of a sudden we're getting out of for, um, if the employer really did nothing wrong for nothing. If the employer did something wrong, but not as wrong as we thought, then for something, but for much, much less than maybe we thought from the outset.
So tell me about the $5 million verdict, Sample versus Simix. Is that, I think I pronounced that right? What was the case and what did it take to win that?
That wasn't one of my cases. I'm not sure.
Oh, so okay, so that's my researcher is gone down on this one. So to um, tell me a specific story about a case that you had where you were successfully executed for the client.
So I had a trial last year, and it was a really, really complicated housing discrimination that involved an extremely rare medical condition. So I had to learn about this condition, learn how to be able to explain it to a jury in language that was clear, but also doesn't sound like I'm, talking down to them about this thing that I barely understand. Um, and it was a situation where I think people could understand why the HOA did what it did, even if what it did was wrong. And so, showing the real concrete way that what the HOA did hurt my client, that was very big and very important because we had to kind of overcome that. Like I said, I think people could understand why an HOA did what it did. And it was a situation where my client had a condo in Redondo Beach, and it was one of those ones that's right on the beach. Nobody has air conditioning in those buildings,
Mm-hmm.
and everybody sleeps with their windows open. Mhm. My client had a condition that she needed air conditioning. I mean, it was a medical necessity for her. And the HOA kept saying no, and noise was their concern. And so it was a situation where it was like, a lot of people, especially in Los Angeles County, that deal with noise know how annoying it can be. And so, we really needed to spend time explaining to the jury why, no, this was not a situation of somebody wanting air conditioning because it got a little warm and she got a little annoyed by the temperature, that this was a situation where she would be in excruciating pain without the air conditioning being installed. And that's something, that was really difficult to get the jury to understand because their initial gut was, yeah, noise is a legitimate concern. And to push them over or off of that ledge of that initial feeling was tough, but like I said, it was really just a matter of understanding on a fundamental level this condition and then working on how to explain it.
And you were successful in doing that.
We were very successful. We got a very good verdict. And then um, during the process after trial, it ended up resolving, and so everybody was able to then walk away and move on with their lives.
So you wrote a definitive legal guide on the rights of transgender and non-binary employees in California. What made you take that on?
Um, I mean, it was something that had always interested me. Gender identity, in particular, is something that we're really, as a society, still working on understanding, and we're getting there, but there is still a lot of misunderstanding about the transgender community and about the non-binary or non-gender conforming community. And so the goal with this publication was to be a very simple, easy to understand, both for employers and employees. Here's what your rights are, here's what your obligations are. No more, no less. And if everybody strives to be in that right spot, we'll be in a good place. And so my hope with that article was, Ironically, I was hoping that it would mean fewer people would have to call me. Because if employers paid attention to the advice, it would mean that employees that, like I said, are transgender or non-binary, that their rights are being respected.
I would think in Northern California that that was less of an issue than in other parts of the country is still an issue though.
It absolutely still is an issue, and it also becomes an issue with regards to, well, how far does something necessarily have to go, and where is the line? But also, I take cases throughout the state, so I don't limit myself to the Bay Area. Ironically, actually, right now, I've got more Southern California-based cases than I do Northern California-based cases. But I also take cases in some of the more rural counties, um, and there some of those more rural counties, it very much is an issue.
So, if someone's listening to this and says, um, that that Mike sounds like, somebody I need to talk to, I've got a problem, what's the best way to get in touch with you?
Uh, Email is the easiest way. It's just my last name, Law. So it's Mike, Mike, at Guasco Law, GUASCOLAW.com. And initial consults are always free so that we can talk about issues, and that way people feel like, hey, I can talk to this person and not feel like I'm not going to get anything out of it and I've spent money. So, that initial conversation is always free. If I say, I don't think you've got a case, but if these things happen, give me a call back. Then that follow-up conversation is also free. And that's the
Okay,
easiest
Mike,
way.
thanks a lot for coming on the show. I really appreciate it.
Thank you much. It was really fun, and I look forward to hearing more from you.